Hi, and welcome to the third lecture in this lecture series titled Introduction to International Arbitration Practice. In the first chapter of this lecture series on arbitration agreements, we have been discussing about pathological arbitration clauses. In this lecture, we continue to discuss such clauses. As a non-transactional legal practitioner, you might wonder why we dealt with arbitration agreements in the first place. An arbitration agreement is the first document that is a sine qua non for arbitration. Second, this exercise of discussing pathological or defective arbitration clauses can help practitioners in identifying such clauses and thereafter frame their legal strategy, either before the courts or the arbitral tribunals or other authorities. Also, this exercise helps transaction lawyers in drafting proper arbitration clauses. This is obvious. Transactional lawyering is their bread and butter, and arbitration clauses are, on a larger scale, the dispute resolution clauses form an integral and important part of transactional lawyering. Now, look at this arbitration clause before you. It says disputes. In case of any disputes arising out of this agreement between the parties, the same shall be referred to arbitration under the bylaws of Indian Companies Act 1956, and all amendments of this act up to date or shall be settled and decided by arbitration as per international trade laws, and all amendments of this act up to date. Please pause this video and find out the defect in this arbitration clause. Okay, were you able to identify the defects? The defects was in the phrase with bylaws till the end of the sentence. I'll just read the defective portion for your convenience. Bylaws of Indian Companies Act 1956 and all amendments of this act up to date or shall be settled and decided by arbitration as per international trade laws, and all amendments of this act up to date. So what was the fundamental problem? Firstly, under the law regarding arbitration is contained in the Indian Arbitration and Conciliation Act 1956 and not under the Indian Companies Act of 1956. The second and more fundamental defect is that there is also an option provided, or it shall be settled as per another mode of arbitration. But even in that other mode, it is not specified as to which institutional rules or which rules under which this dispute will be resolved. There is nothing called as international trade laws as an arbitral institution or as a set of rules. Perhaps the drafters of the arbitration agreement were possibly referring to the UNCITRAL model law, or possibly the UNCITRAL arbitration rules, we never know. But it is not a legislative instrument. Therefore, this clause is an example of a pathological arbitration clause. And this emanated in the case of System for International Agencies versus Rahul Coach Builders, a decision reported in 2015. Now we move to other examples of pathological arbitration clauses. Now see these clauses. I just read it for the convenience. Any and all disputes arising under the arrangements contemplated hereunder will be referred to mutually agreed mechanisms or procedures of international arbitration, such as the rules of the London Arbitration Association. The next clause says, if any question or dispute or difference or dispute shall arise between the parties hereto or the representatives at any time in relation to or with respect to the meaning or effect of these presents, or with respect to the rights and liabilities of the parties hereto, then such question or dispute shall be referred either to Mr. N.A. Palkhiwala or Mr. D.S. Seth, whose decision in the matter shall be final and binding on both the parties. The next clause says, any and all such disputes shall be finally resolved by arbitration before the Singapore International Arbitration Centre in accordance with the rules of arbitration of the International Chamber of Commerce, then in effect, and proceedings shall take place in Singapore and the official language shall be English. So again, pause the video and find out where the defects in these clauses are. Did you find out? Now see where the defects are. We have underlined them and have provided the cases where these clauses were discussed. I'll just read the underlined portions, such as rules of the London Arbitration Association. because again there is a reference to a non-existent arbitral institution. This case arose, I mean this clause arose out of the case of Republic of Nicaragua versus Standard Fruit decision. It's a very old decision of 1990s, reported in US cases. Okay, the next clause suffered from the defect that it referred to it specifically provide for arbitrators who would be arbitrating the dispute, but neither of them was alive at the time of the dispute. So this case is the case of ACC Limited versus Global Cements Limited, a 2013 decision of the Supreme Court of India. And then there is another example of an unworkable arbitration clause where the clause provides for reference of arbitration to Singapore International Arbitration Center, but under the rules of the ICC or the International Chamber of Commerce. This clause arose out of the case of Insigma Technology versus Alstom Technology, a 2008 Singapore High Court decision. Again, the Insigma versus Alstom case is an example where sophisticated parties were had drafted this arbitration clause, and it ended up in a huge problem. Right. Now see this clause. That the rights and obligations of the parties under or arising out of this agreement shall be construed and enforced in accordance with the laws of India, and the courts at New Delhi shall have exclusive jurisdiction with regard to all matters arising out of or touching and or concerning this agreement. The agreement also provided all or any disputes arising out of or touching upon or in relation to this to the terms of this agreement, including the interpretation and validity of the terms thereof, and the respective rights and obligations of the parties shall be settled amicably by mutual discussion, failing which the same shall be settled through arbitration. Okay, and look at another clause in arising in some other case. It is also agreed by and between the parties that any dispute or differences arising in connection with these presents may be referred to arbitration in pursuance of the Arbitration Act 1947 by each party appointing one arbitrator, and the arbitrator so appointed selecting an umpire. The venue of arbitration shall be at Bombay. Now the defects are underlined here and the case laws are provided here. So in the first set of clauses, the defect was that there was a reference to dispute and an unequivocal reference to courts also. But then courts generally construe this harmoniously, as if to suggest that in respect of disputes, the matter shall be referred to arbitration. But the concerned courts, in respect of any issue, such as, say, for example, filing of application for appointment of arbitrators under Section 9, Section 11, or for interim measures before a court under Section 9, etc., the referred court would be the court having exclusive jurisdiction. Right? This fact situation arose out of a Delhi High Court case of AEZ Infratech versus SNG Developers. That was in 2014. There are examples of many such cases in India as well as abroad. Now, the next clause, which was actually a pathological clause because it was an incomplete arbitration clause. The clause said the disputes may be referred to arbitration in pursuance of the Arbitration Act 1947. There are two defects here. The first defect is that the reference is to Arbitration Act 1947 when there is no such act. In India, the Arbitration Act was either 1940 or the 1996 Act. Now, the second and more problematic issue is that it provides for reference by parties in an optional way. It uses the phrase may be referred. So this clause arose in the case of Wellington Associates versus Kirit Mehta, a 2000 Supreme Court decision. Right. There are many other examples of pathological arbitration clauses. For example, there is the defect is unclear reference to arbitration, where the clause provided an arbitrary commission applying French laws. So this arose in the US case of Jane versus D. Mayer. And then and this is a frequent possibility, that there are two arbitration clauses in the same agreement and both are references to different arbitral institutions even. This example arose in the case of Transgreen Shipping versus Limar Shipping, 2014 English High Court decision. I am not quoting the entire arbitration clause here because it's very lengthy, or because there are two arbitration clauses, right? In fact, a similar fact situation arose when I was vetting an agreement way back in 2012 or 13, where one of the two arbitration clauses provided for reference to Indian Council of Arbitration, and the other arbitration clause in the very same agreement, but in different part of the agreement, provided for reference of the dispute to Singapore International Arbitration Center. Right. And then there is another example where the clause is not exactly an arbitration clause, but seems to be so. I'll just read it out for your convenience. Subject to section 20, subsection B, brackets arbitration, any dispute, disagreement, or proceeding arising under this agreement shall be subject to the exclusive jurisdiction of the courts at New Delhi. But then there is no section 20, subsection B in the agreement dealing with arbitration. So perhaps there were two subsections in the agreement. One was containing arbitration, and the other one was providing for exclusive jurisdiction of courts at New Delhi. But then, if probably because the parties' agreement, that clause relating to arbitration was deleted, but the phrase subject to was not removed, then perhaps because of this reason, this defect arose. This arose in the recent case of Universal Design Build versus Deals Cart Online Services, a 2021 decision. Now, the manner in which courts resolve defective arbitration clauses is varied. This slide explains to you how courts have resolved the pathological arbitration clauses that have been mentioned just now. Take the case of Pricol versus Johnson Controls Enterprises. We discussed this case in lecture 1 or lecture 2. Yeah, possibly the previous lecture 2. So here, what had happened is the defect was that there was a reference to non-existent arbitral institution. The outcome was that court referred to arbitration. The rationale provided by the court was that the court rewrote the defective part of the arbitration clause by supplying reasonable meaning in the context of the arbitration clause. Then again, sometime back in this lecture, we discussed the defect in system for international agencies as Rahul Koch Filters, where there was a reference to non-existent rules. So the court did not refer the matter to arbitration and held that the clause was invalid or unenforceable for vagueness. Then again, in ACC Limited versus Global Cements, the reference was to arbitrators who were no more alive at the time of dispute. The matter was referred to arbitration because there was the intent to arbitrator to refer the matter to arbitration could be culled out from the arbitration clause, and the parties could appoint substitute arbitrators. And in Sigma versus Alstom, where SIAC was to administer the arbitration, but under the ICC rules, the clause was unworkable, but the matter was nevertheless referred to SIAC arbitration because the Singapore High Court said that this clause should be implemented to the maximum extent possible by SIAC. Again, AEZ Infratech versus Essential Developers was a case where the matter was referred to arbitration, even though the arbitration clause suffered from the defect of reference of dispute to arbitration as well as to court, because the court said that these two clauses should be harmoniously construed. And then in Wellington Associates versus Kirit Mehta, the matter was not referred to arbitration in view of the incomplete arbitration clause because the court could not cull out an unequivocal intent to arbitrate. Again, another pathological clause where there was an incomplete arbitration clause was in the Universal Design Build versus Deals Card, where again the matter was not referred to arbitration for the same reason, no unequivocal intent to arbitrate. But look, there is no foolproof method to predict whether your pathological arbitration clause would be referred to arbitration or not. It would depend on the jurisdiction or the court where the clause is in question and the judge hearing the case. However, It is possible to state a general principle that in case the intent to refer disputes to arbitration can be clearly culled out from the pathological arbitration clause, courts would generally refer disputes falling within such clauses to arbitration, even though the clause might suffer from certain defects. That's all in this lecture. Have a great day.